Good afternoon. I'm your host, Brian Buckmeyer, here at Justice and Peace. We've got a number of stories with you, but let's start off with Andres Guardado. We have some new information about the autopsy report that was recently released. The issues here is that the autopsy report seems to conflict with the officer who is alleged to have shot him. The officer says that he was reaching for his waistband, but the autopsy says he was shot 5 times in the back. Now, that officer has not been interviewed as yet, but the family is asking for more answers from the questions that they're trying to get through to them. Let's start off with the presser, where they're talking about the autopsy report and how Andres died because of 5 shots to the back.
More controversy tonight in the shooting death of an 18-year-old Andres Guardado.
The LA County Coroner's Office confirms the teen was shot 5 times in the back. KCAL9's Hermela Aragawi reports now the coroner released autopsy results in defiance of the LA County Sheriff.
The LA County Coroner's Office says the release of the autopsy was the right thing to do. In a statement, Dr. Jonathan Lucas said, "In doing so, I have given careful consideration to the major variables in this case, supporting the administration of justice as well as the public's right to know. I do not believe that these are mutually exclusive ideals." He added, "I believe that the government can do its part by being more timely and more transparent in sharing information that the public demands and has the right to see." The report matches what an independent autopsy found, that 18-year-old Guardado had 5 total gunshot wounds, all entering the back and all fatal.
I was able to go to the autopsy because the sheriff couldn't stop me.
Max Huntsman is LA County's Inspector General. He says the LA County Sheriff's Office has repeatedly ignored requests for documents and video in the investigation of the June 18th shooting.
The Sheriff's Department has failed to follow transparency and oversight laws. We have state law and county code that require cooperation with the Office of Inspector General, which I run, to monitor a lot of things that happen in the Sheriff's Department, including shooting investigations, and they've refused to follow that.
Or I'm joined with Lakai Vincent, a criminal defense attorney, as well as Bernardo Villalona, former prosecutor. Good morning to you both. Bernardo, let's start off with you. I mean, first we have someone who's literally leaking information because they do not feel that the LA County's Sheriff's Office is following their own rules of releasing information. What did you make of the way that this information got sent out to the public at large?
Well, I think there's a huge conflict within the police department, the sheriff's department, as well as within the DA's office as to how this case should be handled. So that's why there is a need for, when there is a police-involved homicide, for a special prosecutor to be appointed so there can be some more transparency between the investigation and the public itself. So what do we know from this shooting that took place on June 18th? All we know is that 2 sheriffs were involved. One of those sheriffs fired 5 shots into the back of Mr. Guardado. That's what we know now, because there are no body camera footage, and supposedly the video camera footage that was recovered from the auto body shop as well as from surrounding areas so far now has not been able to shed any light.
Yeah. Now, Lakai, I see a situation where it's a balancing test, where I understand to some degree that they've got to do an investigation, and they can't have us as the public coming in at each and every step to kind of criticize all those steps. I get that. But it seems like it's being poorly balanced, where these entities, being the coroner's office and the county and the sheriff's office, can't even get on the same page. So we're all left with, guys, we don't know what's going on, and they have to bury their son, their teenage son, without all the facts. That seems to be missing the point here.
Exactly, Brian. I think it makes it certainly difficult for the family and the public at large to understand what is going on here because of the lack of transparency. And when you have 2 entities who are supposed to be running the show directly in conflict with each other, you don't know who to necessarily believe and who to lean on when it comes to this information. So it makes it inherently difficult for the family and or the public to trust either entity because of their conflicting stories.
All right. Let's continue now. We're going to look at the sheriff's presser, where they're talking about the case and the information that they're putting out forward.
There were 2 Los Angeles sheriffs involved in this incident. who gave chase to Andres Guardado on foot, which ultimately led to the deputy involved shooting. The deputy who did not fire his weapon has been interviewed by Sheriff's Homicide Bureau. The principal deputy who did in fact fire his weapon and struck Andres Guardado is scheduled to be interviewed by Sheriff's Homicide Bureau investigators, but that has not yet occurred. The cameras seized at the scene pursuant to a search warrant did not contain any video recordings of the event. We are aware of the independent autopsy conducted at the request of the Guardado family. We have not yet been notified by the Los Angeles County Medical Examiner that the official autopsy report has been completed. A security hold of that report was requested by homicide investigators until all interviews have been completed. Homicide investigators requested that security hold in order to prevent any compromise in this investigation. I've also learned that there's some reports, either on social media or in the media, that the gun recovered at the scene was not real or a toy. That is not correct. The gun has been tested. It is in fact a real firearm.
So Bernardo, I fully get it. You don't want to give out too information before you actually get it from the source, that being the person who discharged a firearm. I also understand that unions are pretty strong and they can delay that. But wouldn't the simplest answer be, if there's a police shooting, the officer who actually did the shooting, not the person who was just there, but the officer who did the shooting gets interviewed within 24, 48, 72 hours, whatever you want to call it, so it avoids all of this problem?
See, Brian, what you said makes sense. However, you have to think that because it's a criminal investigation, this sheriff, he is still entitled to the same constitutional rights just as anyone else who's under a criminal investigation. He's entitled to his Fifth Amendment right not to incriminate himself. Because if it is later determined that this case is a homicide and that he was not justified in this shooting, then he is going to be charged. And whatever he says to these people that are interviewing him can be used against him. So he still has his constitutional rights, even though he is a sheriff. While everybody wants to know what happened, tell us what happened, he has to maintain his constitutional rights. And also take into account that since people were talking about, oh, that information wasn't being released, I understand the sheriff's position about information not being released and the prosecutor's position, because you don't want to release so much information when you have a person that is a person of interest that hasn't been interviewed. You don't want that person to tailor his interview or his statement, if he were to give one, to the facts that are being put out to the public. So you don't want that to be tainted by anything that's being put out to the public. So that is the balancing test that must be taken.
So Bernardo, I understand the balancing test, and Lakai, I'll punt it to you. I'll ask this follow-up question from what Bernardo is saying. If that person wants to invoke their Fifth Amendment rights, that's perfectly fine. I get that. We're not going to get a statement from them, but you can still go forward with the case and simply say this person chose not to give us a statement, whether it be for Fifth Amendment rights or based on their union or whatever it may be. But this is the information we have thus far. We're just not including this person's statement because they chose not to give us information. Like, why would that not work?
See, the problem is, Brian, I'm sorry. So the problem is, Brian, in this case, is that because there's no body camera and there's no surveillance video of the actual shooting, all you're left with is the person that was involved in the shooting and his partner and whatever eyewitness testimony that you can get. And my understanding is that so far there haven't been any independent witnesses that have stepped up and been able to tell what took place. So without the officer testifying, the shooting officer and his partner, if he saw the entire situation taking place, you don't have anything to go forward with in a prosecution. What would you present to the grand jury? What would you present to the judge? You need someone to testify that you saw this officer shoot this person in the back. You may be able to do it and say it circumstantially that he did that, but how about if there's any information that Mr. Guardado had the gun and turned and pointed the gun at him or whatever may have taken place? You don't have that.
Lakai, same question. Why couldn't we just say, okay, he's invoking his rights. We get that. We can't ask him the questions, but we interviewed the other officer, and based on that, interview and the autopsy, we have enough to go forward, and this is what we'll tell the community?
Well, Brian, I think that they want to build the strongest case possible. And the case would certainly be stronger if they have an admission by that officer. I don't know that we'll get to that place, but we know that cases move forward all the time based on circumstantial evidence. This is not any different. There was an eyewitness. We don't know to what extent he saw the actual shooting, but we know that there was an officer there that didn't actually shoot Mr. Guardado, but he was there. There was also potential video that we're still trying to determine whether or not it's going to uncover anything that's helpful. But I think, like you said, Brian, we don't want to continue to delay it. There's already issues when it comes to credibility and transparency. And when you delay this investigation and potentially delay prosecution, then you certainly lose additional credibility with the police department. And that happens time and time again in our community.
Yeah. And again, I think, Lakai and Bernardo, you give us great points. And I think those are the facts on either ends of the scale, and they have to be balanced out. But I think we always have to look to that scale on a case-by-case situation based on the information that we do or do not have and ask, are these two sides balanced? But we're going to continue to talk about this case. Bernardo, what would you think would be necessary in this case to kind of tie it all together to be like, all right, now we're going to release in just kind of 10, 15 seconds? What do you think we're really missing?
I think what's missing is an actual account of what happened from beginning to end, because if they had that actual account from beginning to end from the partner, the sheriff who was with the shooter, I think they would have been able to move forward. But I think that is exactly what is missing, is that they don't have a 100% account of what happened.
All right. So let's continue with another story. We're going to take a quick break and we'll come back to more here at Justice and Peace. All right, so let's go back to St. Louis. The couple who we saw in a viral video pull out a handgun as well as an AR-15 when protesters went across what we believe, or what we've seen so far, to be public property to go and protest. Now, the couple believes that these individuals were breaking property and trespassing, but we found out a lot more about the couple that kind of paints a broader picture. Let's start off with a video that went viral and that brought us to this story initially. Let's take a look. All right, you've got to say it off the bat. The only video that we have seen thus far is no one entering the property. But of course, I know the husband has gone on the news saying that people are encroaching on his property. But when you start to look at the history of this couple, things get really interesting. Lakai, I want to bring you in on this first one. The first one that really shocked me, from what I understand, a Jewish community group had installed beehives on the opposite side of their wall for that private home, and they were using it for religious. They were going to cultivate the honey for religious ceremonies. The couple tore down those beehives, and then I believe it would probably be in jest, but still, it's kind of wrong. Threatened to shoot them if they did not clean up the mess. Does this paint a picture of the character or the people that we're talking about in this case? What are your thoughts?
So, Brian, first of all, as I sit here and I even begin to talk about this couple, you wonder if they're watching, and if they do see it, whether or not I'll be named in the suit based on whatever I share about them. But if you look at their history, I mean, they're certainly a litigious couple. Now, granted, they're both attorneys, but it's bizarre the amount of lawsuits that they file and the people that they file the lawsuits against. You talk about them tearing down the honeybee hive. It's my understanding that there were many kids that were disappointed. It was an educational opportunity for them. And then they threatened that if it wasn't cleaned up by somebody else, that they would sue them. So this is something that is ongoing for them. They have a history of suing people over and over again for ridiculous reasons. So this is consistent with their character based on everything that they said in lawsuits, in depositions, and in suing not only their sister, but the husband's father.
Yeah, and let me correct myself because you did, Lakai, as well. It wasn't threatening to shoot. It was threatening to have a restraining order and have that group pay the attorney fees as well. So they are very litigious people. Bernardo, the one that stuck out to me the most, and that was very interesting, was a bit of litigation within the HOA, where that piece of property or that little bit of land, I think the HOA says that is public property, just on the other side of the sidewalk from their property. So it would be their property, sidewalk, and then piece of grass. I think most of us would say that the land or the grass outside of that sidewalk is public. They tried to argue with the community that that is theirs. And I found that interesting because that was the piece of grass that the protesters were actually walking across. So maybe in their mind, they just think that this is all their property. How does that go into the calculus of what they did?
Look, Brian, when you look at the McCloskey couple, the reality is that you see this sense of entitlement that they carry. I mean, they feel so entitled and so privileged that they can do and say what they want. What else would have emboldened them to come out from their property with an AR-15? I mean, look at that rifle. Like, it has a long magazine that I think carries about 30 cartridges inside of it. For you to be emboldened to come out when you see just people walking down on what's public property, because that piece right there is common ground for anyone. They're not going up the steps. They're not going inside of your house. And if they're not going on your property or inside your house, then there is no need for you to feel any kind of threat that you need to take out an AR-15 and take out a firearm to so-called protect yourself. From what? From people talking, from people exercising their First Amendment right to free speech? No, this is an entitled couple exercising their privilege.
Yeah, and I will say the last report that I've heard about this is that the local police department did confiscate the AR-15. Whether or not they have other weapons, I'm not sure, but that seems to be one of the few steps the police have taken in that situation. Let's switch gears now and talk about the Breonna Taylor case, because in that case, we're getting a little bit of a development. It appears that the Metro Council has requested certain information from the mayor's office, but the mayor is saying, similar to other cases we're covering here, that because of an ongoing investigation, that information cannot be released. How that all played out was very interesting because an actual letter got sent out to the office. Let's take a quick look at how that played out.
Louisville Mayor Greg Fischer denies the Metro Council's request asking he turn over all documents related to the Breonna Taylor case. In a letter sent to council members on Sunday, Fischer says, quote, "While I take your requests in good faith, I must misunderstand your request for the release of all documents that relate to the Breonna Taylor case, given the fact that your request would include the investigative materials currently being reviewed by the FBI, the Department of Justice, and the Attorney General for potential criminal prosecution." Last week, Metro Council wrote that if the mayor didn't release all those documents from the case, including recent allegations that her death was tied to gentrification, there would be, quote, "clear and decisive action by the Metro Council."
All right, Bernardo, let me come to you first. Does it change the analysis? Because I know earlier you said in the Andrea's case that releasing information to the public can be detrimental, and you laid out some very strong points as to that. My question for you here, does that analysis change, or is it stay the same when it comes to releasing information to the Metro Council? Because that would not be the public, but just another entity, I would assume, unless the council is saying we're going to release it to the public afterwards. That's another entity rather than the public. Does that change, or does that stay the same for you?
It stays the same for me because the Metro Council is still the public. Remember that the Metro City Council, they represent and answer to the public. So you're not sure how any privileged information is going to be disseminated outside of the City Council. Again, they are doing an investigation, and you have three different entities. You have the FBI, you have the DOJ, and you also have the Attorney General's office or the special prosecutor that's investigating this case. So certain details should not be released to the public. However, I understand how it's impeding the civil case to the point where the family for Breonna Taylor has filed a motion, a contempt motion to release some of these documents to them. But the most important people that should be having this information and these documents are those that are going to pursue the criminal prosecution, if any.
Now, Lakai, we know that Breonna Taylor's attorney filed a motion saying that there's something fishy here, that these types of warrants may be connected to gentrification at large. And so part of the council's request is to get information to see if that claim holds water, to see if that makes any sort of sense. What do you make of that request and how it was answered by the mayor?
Well, Brian, I think it's a reasonable request. And while we talk about balancing act, let's compare the fact with the Guardado case that happened approximately 20 days ago or so and Breonna Taylor. We're talking about over 100 days since we've been waiting for information. We've been waiting for the potential arrest or charges of these officers. So when we're talking about a balancing act, we have to consider the balancing. And over 100 days is just not acceptable. So the scale is certainly off at this point. So I think while it's reasonable to respond that way when it comes to the mayor's office within maybe the months the days following the killing of Breonna Taylor, at this point we're talking about over 100 days, and I certainly think it's ridiculous.
Yeah, and I think I understand different cities, different situations, different place, but we have the entire country and the world watching and saying, hey, 20 days here, but 100 days here, how long do we have to wait? Not sure. But Bob Bianchi, what do you got for us coming up next?
Hey, first federal execution scheduled for 4 p.m. today. In 17 years, there hasn't been a death penalty conviction of a killing of 3 people. The twist, Brian, the family does not want the man executed.
That's going to be interesting, the balance between what the criminal justice system wants to go forward with and what the victims of the case also want as well. We've seen that in other cases with Amy Cooper. This is going to be interesting. We're going to continue with Justice and Peace tomorrow, but make sure to be here for Bob Bianchi for Keeping the Peace in just a few moments.